friends, today we will begin our lecture with the system of courts in India. Before we enter into the system of courts as it exists today, we will go into a short historical overview of the system of courts. In India, the legal and judicial system is as old as 5,000 years, and we find various references to this in the texts and other books. We had a very well-established judicial system, and we find this in the Dharma Sastras. There were elaborate laws which contained various aspects of the human conducts, and these were called the dharmas. Now, dharmas were segregated into different categories, like the Raj Dharma, the Griha Dharma, the Varna Dharma, and these had to be strictly followed. There were sanctions imposed for non-observation of dharmas, and there was a well-organized system of law for the administration of civil, criminal, and revenue justices. Now, ancient Hindu rulers, especially Ashok, Chandragupta Maurya, Harshavardhan, Kanishka, were very diligent advocates of justice, and their system was highly developed. Now, with the Muslim rulers, they introduced their own system of administration of law. So what happened was, after the advent of the Mughal rule in India, we had two different systems of administration of law, one which was followed in the Muslim territories ruled by the Muslim rulers, and the other followed in the Hindu territories ruled by the Hindu rulers. So therefore, with the entry of the East India Company in India itself, we find that there was a dichotomous or two different kinds of system of administration of justice in India. Now, with the British Company, they came and they established their own system of administration of justice. Now, and this became more consistent with the area that they started developing or controlling. So now what happened is there were phase-wise development in the administration of justice in British India. Now in the first phase, the British settlers, they settled into Surat, Mumbai, Madras, and they put into place an elementary judicial system which was basically to settle mutual disputes between the people, and this was entrusted to non-legal, non-professional Englishmen belonging to the trading company. Now, in the second phase, we have the establishment of the Supreme Court of Judicature in the Fort William in Calcutta under the Regulating Act of 1773. This is a landmark development in the legal system in India, but what happened is, development, what it did was it gave more power to the judicial system, and there was a tussle between the executive and the judiciary with regards to administration of justice at that time. So then, in the Settlement Act of 1781, two different institutes of the British East India Company was segregated, it was separated, and they became independent of each other. Now, the third phase, it involves the introduction of the Adalat system in the Mufassils, which was manned by the executive civil servants having no legal training. Now, subsequently, the judicial functions were separated from the executive functions. Now, the fourth phase of establishment was the establishment of the high courts in the presidency towns, and the fifth phase is the emergence of the Privy Council as the highest court of appeal in the by the Government of India Act 1935. Now, the federal courts continued till the 26th of January 1950 until the Indian legal system as it stands today was established by the Constitution of India. Now, before we enter into this, what we must understand is the court system as we understand today is basically what we have modeled after and what we have further developed from what the British left of the legal judicial system. Now, there are different forums in the current judicial system, there are different forums of redressal of dispute. Now, the first forum or the first general system is the conventional courts. The second is the special courts. The third is the alternate dispute resolution system. And the fourth is an establishment of a quasi-judicial authority, which is known as the tribunals. Now, first we will discuss regarding the conventional courts. Now, what is the conventional court? In India, there is a hierarchy of judicial system. Now, if we begin from the top, we have the Supreme Court at the top, and the Supreme Court was established by the Constitution of India under Article 124. Now, the article provides that there shall be a Supreme Court in India consisting of the Chief Justice and any number of other judges as prescribed by the Constitution. Now, they are to be appointed by the President. Now, thereafter the Supreme Court, we have the different high courts in the different states. Now, every state has a high court of their own, but it may so happen that two different states may share a single high court, and a state and a union territory may share a single high court. Like, for example, the state of Punjab and Haryana, they have a single high court, the High Court of Punjab and Haryana, and the state of West Bengal and the union territory of Andaman and Nicobar has a single high court, that is the High Court of Calcutta. Now, the high courts generally or ordinarily sits in the state capital, but the High Court may also hold circuit benches in other places apart from the place where it ordinarily sits. Now, just below the High Court, we have the subordinate courts. Now, the subordinate courts is basically the district judiciary. Now, each district has its own judicial system. Now, there is the different courts in the different states may be called by different names, but the hierarchy in the judicial system and the district is similar. So, we will begin with the lowest rung of the ladder. Now, in the lowest rung of the ladder in the district judicial system, we have a cadre that is called the Civil Judge Junior Division. Now, just above the Civil Judge Junior Division, we have the Civil Judge Senior Division, and above the Civil Judge Senior Division, we have the District Judge Entry Level. Now, the Civil Judge Junior Division, the Civil Judge Senior Division, and the district judges, who also include the additional district judges, they exercise civil powers. Now, the Civil Judge Junior Division and the Civil Judge Senior Division, when bestowed with criminal powers, special criminal powers under the Criminal Procedure Court, will act as magistrates of the first class, second class, and they are invested with criminal powers. Now, the sessions judges or sub-judges, as we call them, the Civil Judge Senior Divisions, when they are vested with special sessions power, they can hold criminal trials. And the district judges with sessions power will hold criminal trials depending upon the jurisdiction of different courts. Now, a Civil Judge Junior Division who is invested with criminal powers is called a magistrate. Okay, and a Civil Judge Senior Division who is invested with criminal powers is called either a Chief Judicial Magistrate or an additional Chief Judicial Magistrate. Now, the additional Chief Judicial Magistrate or magistrates in the metropolitan area, the judicial magistrates in the metropolitan area are called metropolitan magistrates, and Chief Judicial Magistrates and ACJMs or that level of officers in the metropolitan areas are called ACMMs, that is Additional Metropolitan Magistrates, or CMMs, that is Chief metropolitan magistrates. Now, under this regular system, we also have something called the special courts. Now, these judicial magistrates, chief judicial magistrates, sub-judges, sessions courts are sometimes invested with special powers for exercising special jurisdiction under a special act. So now when these courts are invested with special powers, special jurisdictions under a special act, they are called special courts. Now, what are the different special courts? The different special courts are like, for example, when a judicial magistrate is empowered to act as a member of the Juvenile Justice Board. Okay, so here a Juvenile Justice Board is established to deal with offenses committed by people who are below 18 years of age. So they are basically called juveniles in conflict with law. Or now the correct terminology is child in conflict with law. So any offense committed by a child in conflict with law is considered or tried by the Juvenile Justice Board, and the specially empowered magistrate is the member or one of the chairmen of the board. Now similarly, you have the special courts for MPs and MLAs, that is for trying cases committed by MPs and MLAs. You have the commercial courts for commercial disputes. You have the NDPS courts for offenses committed under the NDPS Act. You have the electricity court. So these are different special courts which are created within the purview of the conventional court systems. And what is important is that these special courts also exercise their regular criminal and civil jurisdiction. Now, another important special court is the POCSO court, as we generally know it now, especially for dealing with offenses or sexual offenses against children. So these are the regular court systems of the conventional courts. Now, this is a hierarchical appellate forum. So any decision of the lowest rung will go to the upper rung, then above. So the system of appeal is according to, for civil laws, is considered under the Civil Procedure Code, and for criminal laws under the Criminal Procedure Code. So with this we come to the conclusion with regards to the conventional court system in India. Now the other mechanism, which is a very important aspect and which has been receiving much talk and which has been receiving much impetus now, is called the alternate dispute resolution system. Now, what is an alternate dispute resolution system? An alternate dispute resolution system is a method by which you settle your disputes without going into conventional court litigation. Now, in a court litigation, which is an adversarial system of justice, there are two sides. So in every dispute, there are two sides. So, but what happens is the procedure in court is very cumbersome. Now, in the alternate dispute resolution system, without going into court, you try and settle your matters either by mediation, by lok adalat, by arbitration, or conciliation. Now, these are the four systems, four different authorities which help in the mechanism of alternate dispute resolution. Now, the system of alternate dispute resolution has also been given importance in the CPC under section 89, which says that even in a regular civil court, before you enter into trial or at any stage, the court should at least make an attempt to settle disputes alternately either through arbitration or through mediation or through lok adalat before entering into a procedural adjudication of the dispute. Now, this system of dispute resolution has gotten much fillip after the enactment of the Legal Services Authority Act in the year 1987. Now, the the Legal Services Authorities Act in 1987 saw the establishment of the National Legal Services Authority, the State Legal Services Authority, the District Legal Services Authority, and again, these authorities also encourage you to settle your disputes against the conventional system by the system of, again, arbitration, mediation, conciliation. Now, the Act also enables the legal awareness of local people, of students, and does not use the regular conventional method, but they involve other government bodies, social services, and we have now a new body of people who are helping in this alternate dispute resolution mechanism called the paralegal volunteers. Okay, so these are people who are helping in the settlement of dispute without entering into the conventional legal system. Now, the arbitration and conciliation of disputes is also governed by the Arbitration and Conciliation Act, and the impetus to try and settle disputes without entering into the conventional method is also found in the CRPC, where there is compounding of offenses and mechanisms where you can withdraw and then compound your offenses, etc. Now, this is like, in short, the alternate dispute resolution mechanism. Like, there is much more which can be said about that, but we will now move into another segment of the discussion which deals with tribunals. Now, a tribunal is also a system of dispute resolution mechanism. Now, what is a tribunal? A tribunal is a quasi-judicial institution, and it is basically set up to settle problems relating to administration, tax, and other specific matters. Now, the function of the tribunal is basically to adjudicate dispute, determining rights between disputing parties, making administrative decisions, reviewing administrative decisions, and others. Now, the word tribunal is derived from the word tribune, and it has a Latin origin. Now, this is basically the tribunes held by the magistrates under the classical Roman republics, and they were these tribunes under the classical Roman republics were usually protecting the rights of citizens from the arbitrary actions of aristocrats and magistrates. Now, a tribunal is generally either a person or a body of persons or an institution that is given the authority of a judge to adjudicate or determine certain claims and disputes. Not all claims and disputes, but only certain claims and disputes. Now, what is the necessity of a tribunal, or for that matter, a special court or the ADR mechanism? Now, that is basically the big pendency, the huge pendency that we have in the conventional court system. Now, we have so much pendency, and the conventional judiciary is so overburdened that it takes years and years and years and protracted and cumbersome mechanism to settle a particular dispute between the parties. Now, what the special courts, the ADR mechanism, and the tribunal does is it shortens the period in which the dispute can be settled. And another thing is that it lessens the burden of the conventional courts. Now, Another important aspect of the tribunal is that it is not necessary that a judge or a person knowing the law has to be the person who is adjudicating in a tribunal. Here, a person who has the specific knowledge with regards to that specific dispute may be appointed as a judge of the tribunal. Now, in the Constitution of India, we did not have any specific provision for the establishment of the tribunals. So, by the 42nd Constitutional Amendment Act, in the year 1976, we introduced two important articles. One is Article 323A and the other is Article 323B. Now, these two articles, they envisaged the establishment of administrative tribunals and other tribunals either by the parliament or by the state legislature to adjudicate specific matters in sub-clauses mentioned in the articles. Now, a comparative study of Article 323A and 323B is necessary to understand basically the different types of tribunals that are established by these two articles. Now, under Article 323A, it is an central administrative tribunal. It can be established only by the parliament, and it contemplates the system for public service matters only. Now, the article envisages one tribunal for the center and one tribunal for each state or for two or more states. And there is no hierarchy in these tribunals. Now, under Article 323B, these are tribunals that relates to other matters. Now, for any specific matter, this tribunal may be set up. It may be set up either by the parliament or by the state legislature, and like these are these matters which relate to foreign exchange, taxation, import, export. These are the tribunals set up under Article 323B. Now, there is no hierarchy of tribunals even under this system. Now, what is important is, what are the other different types of tribunals? Like there is this water dispute tribunal, then the National Green Tribunal, the Administrative Tribunal, the Armed Forces Tribunal. These are, I have given you a list of the tribunals and the acts which have established the tribunals, and also the appellate authority of the tribunals in the study material provided under this system. But to make matters short, what is important is that there are different kinds of tribunals established for different kinds of dispute mechanisms with specific issues related for the purpose for which the tribunal is established. Like example, the National Green Tribunal is basically a tribunal that looks into environmental matters, like to see that there is no harm to the environment, how many industrial pollution is affecting the environment, whether license should be given to a particular industry to set up factories in certain protected areas. So this is what the National Green Tribunal does, and any dispute relating to these matters are done by the heard by the National Green Tribunal. Now, the Industrial Tribunal relates to industrial matters, the Income Tax Tribunal with relating to income tax matters. So these are basically the tribunals. Now, there is a difference between a court and a tribunal. Now, what is a court? A court is a part of the judicial system, whereas a tribunal is an agency which is created by a statute but is invested with judicial powers. A civil court has judicial powers to try all suits of civil nature unless its jurisdiction is explicitly barred, but a tribunal is a quasi-judicial body which has specific jurisdiction in specific matters. Now, the judges, they function as independent persons, independent of the executive, It has no control. Then the executive has no control over the judges. Whereas the tenure, the terms, the decisions and service matters of the tribunal is controlled by the executive. Now, the presiding officer of the court is always trained in law, whereas a member of the tribunal may not be trained in law. And he may be an expert in the specific field for which the tribunal is established. A judge is always impartial and must strictly follow the principles of nemo judex in causa sua or the audi alterum partem, and must never be interested in the matter presented before it. But this is not so of the tribunal, because a member of the tribunal may be a party to the dispute, but the tribunal must follow the general principles of the natural justice. Now, the court is bound by all the rules of evidence, whereas a tribunal is not bound by the rules of evidence. And in court, the matters must be decided objectively on the materials and record. In the tribunal, the decisions are subjective and objective. A court of law can decide the legality of the legislation. A tribunal cannot decide the legality of the legislation. So therefore, this is the basic difference between a court and a tribunal. So I hope you have been able to understand the structure of the dispute resolution system in India. And we come to the end of this lecture. Thank you.